Okay, let's dive right into this. Welcome to This Explainer. Today we're going to unpack one of the most, frankly, extraordinary legal showdowns in modern history. We're traveling back to South Africa in 1999. The country is a newly birthed democracy, the scars of apartheid are still incredibly fresh, and the legal system, well, it's being tested in ways literally no one could have predicted. So we're going to analyze the anatomy of a massive legal crisis, a moment when the president of the nation, the absolute icon Nelson Mandela, found himself pitted against the very constitutional court he helped establish. Right off the bat, we're faced with a massive foundational question about the nature of justice itself. I mean, think about it. Can a judge truly be impartial if the person standing before them in court is the exact same president who signed their appointment papers? And not just any president, we're talking about Nelson Mandela here, a global icon of liberation. If you're a litigant going up against a figure of that sheer magnitude, how can you ever feel totally confident that the court won't, naturally lean in his favor? This wasn't just some abstract debate in a law school classroom. It was the central, incredibly high-stakes dilemma of a real case that threatened to completely derail the highest court in the land. To really grasp the sheer scale of this crisis, we need to talk about the number 5. A litigant actually did the unthinkable and formally asked half of the sitting constitutional court, 5 out of the 10 judges present, to recuse themselves from the case. Now, the Constitutional Court in South Africa sits en banc, which basically means all available judges hear every single case, and their quorum is 8. So if these 5 judges step down, the quorum would be broken. The court physically wouldn't be able to hear the case unless acting judges were appointed, and that would have triggered a whole new massive constitutional crisis. The stakes here could literally not have been any higher. Section 1, an unprecedented legal challenge. This whole conflict centered around Dr. Luyt, a really powerful rugby boss, and President Mandela. So how exactly does a dispute over rugby administration escalate into a full-blown constitutional crisis? Well, the timeline here is absolutely critical. The government had launched an inquiry into the finances of the South African Rugby Football Union, or SARFU. Dr. Luyt and SARFU fought this fiercely, and in April 1998, a high court judge actually ruled in favor of Dr. Luyt, throwing out the government's inquiry and even making adverse credibility findings against President Mandela himself. Fast forward to December 1998, and the president appeals directly to the Constitutional Court. With that huge appeal looming in early May 1999, Dr. Luyt's legal team pulled a totally drastic maneuver. In mid-April, literally just weeks before the hearing, they sent formal letters demanding the recusal of the judges. This was definitely not a slow burn, you guys. It was a rapid, intense escalation right into the chambers of the highest court. Which brings us to Section 2, interrogating the judges, a completely unorthodox demand. You see, Luyt's attorney used a highly bizarre method here. Usually, if a lawyer is worried about bias, they'll respectfully request a private meeting in the judge's chambers with opposing counsel there to talk it out. But instead of that, he sent a written interrogation directly to the judges, and the demands in this thing were just staggering in their scope. They wanted to know, did the judges have any active political affiliation in the past? Did they assist Mandela's party, the ANC, during the tense negotiations for the interim constitution? Was there any social contact at all between the judges and President Mandela? Did they harbor personal animosity toward Luyt's attorney? It was this rapid-fire checklist of suspicion. They were literally asking the highest court's judges to submit to an interrogation about their private lives, their professional histories, and their political pasts, all based largely on rumors. Crazy, right? Well, the response from the court was firm, to say the least. Chief Justice Arthur Chaskalson wrote back stating very clearly, "I do not consider that any judge, let alone the entire constitutional court, should ever be asked to respond to interrogatories." The court didn't view these letters as standard legal procedure at all. They saw it as an improper slander of the institution itself. Chaskalson pointed out that the judges were appointed via incredibly strict constitutional procedures, and casting these wide, basically baseless aspersions on their integrity was completely unacceptable. The message was clear. If a litigant had actual facts to ground a recusal, they needed to bring a formal application, not hand out a pop quiz to the bench. Section 3. The test for bias. So, the crucial point is, how do we define the threshold? When a litigant feels the court is stacked against them, what is the actual legal mechanic used to measure that claim? I mean, it can't just be based on someone feeling a little nervous about losing, right? The court had to lay out exactly what the legal threshold is for forcing a judge to step down, and that core threshold is known as the reasonable apprehension of bias. Break this down with me for a second. It's a suspicion of partiality that might reasonably be entertained by a fair-minded, informed lay litigant. The key words here are reasonable and informed. You really have to put yourself in the shoes of a regular, objective person who actually has all the correct facts of the situation. You can't base your suspicion on incorrect information, paranoia, or just a basic misunderstanding of how the law works. The apprehension absolutely has to be objectively justified. And this brilliantly illustrates a massive distinction the court had to make: the difference between actual bias and the appearance of bias. Actual bias means you can conclusively prove the judge is demonstrably prejudiced, like maybe they have a financial stake in the outcome. But Dr. Luyt wasn't arguing actual bias here. He was arguing for the appearance of bias. He was essentially saying that given Mandela's truly iconic status, the fact that Mandela appointed the judges, and the judges' own political histories, an informed person would reasonably suspect they just couldn't be impartial.
Which leads us to Section 4, the allegations addressed, fact versus fiction.
The Constitutional Court had to basically strip all the emotion and politics out of the equation and treat Luyt's claims purely as data points. They systematically debunked the allegations by comparing what Luyt claimed against the actual constitutional and historical reality. For example, Luyt alleged Mandela appointed the judges personally as a favor. The reality? They were appointed through a rigorous, multi-party constitutional procedure involving the Judicial Service Commission and the Cabinet. Luyt alleged the judges had ties to the ANC. The reality is that any judge who was a member of a political party severed all ties immediately upon appointment to the bench, which is standard practice everywhere. Luyt even pointed out that Chief Justice Chaskelson defended Mandela at the famous Rivonia trial, but the reality was that this professional advocate-client relationship had ended over 35 years prior. Objectively, none of these facts proved a judge couldn't do their job fairly today. Realizing that none of these individual allegations were strong enough on their own, Luyt's legal team tried a new tactic, arguing for a basket approach. They were like, okay, sure, maybe one of these things isn't enough, but if you put them all in a basket and weigh the cumulative effect, a reasonable person would definitely be apprehensive. And surprisingly, the court actually agreed with the logic of this basket approach, but with one massive caveat: you can only put factually correct complaints into the basket. Since Luyt's basket was completely full of incorrect assumptions about how judges were appointed and super outdated historical associations, the basket itself was ultimately empty of objective grounds for recusal. Section 5, judges are not ciphers. Now, what's really interesting about this is how it touches on human nature in the law. The court didn't just toss out the allegations on procedural grounds. They took this incredible opportunity to address a much deeper, fundamental question. What do we actually expect from a judge? To answer this, the court turned to judicial realism, which is wonderfully captured by this quote from former U.S. Supreme Court Justice Benjamin Cardozo. There is in each of us a stream of tendency. Judges cannot escape that current any more than other mortals. I love that. The court was acknowledging that, hey, judges are not robots. They are human beings. They inevitably bring their own life experiences, their instincts, their acquired convictions, and their personal histories straight to the court. They expanded on this idea beautifully, stating, the reasonable person does not expect that judges will function as neutral ciphers. However, the reasonable person does demand that judges achieve impartiality. Think about it. In a young, post-apartheid democracy, it was practically inevitable that the absolute best legal minds would have a history of fighting against the old oppressive regime. Having a political past or having fought for human rights doesn't mean you are just a blank slate, a neutral cipher. Impartiality doesn't mean having absolutely no past. It means having the professional discipline to decide the case right in front of you, based strictly on the law and the evidence, without fear or favor. And that, finally, brings us to the verdict. After days of incredibly tense hearings, the Constitutional Court delivered a unanimous dismissal of the recusal application. All 10 judges agreed. The applicant, Dr. Luyt, totally failed to establish objective grounds for any of the judges to recuse themselves. The subjective fears of a litigant, especially when they're based on flawed information and a fundamental misunderstanding of judicial duty, just weren't enough to unseat the highest court in the land. The court held its ground, protected its institutional integrity, and proceeded to actually hear the appeal. Which leaves us with this final, genuinely profound question to consider. The court openly admitted that absolute neutrality, finding a judge with zero past, no opinions, and no life experience, is a complete myth. So if absolute neutrality is literally impossible, what actually makes a trial fair? Is it strict adherence to the rules of evidence, transparency in written judgments, or is it the rigorous intellectual discipline of the judges themselves? It's a fascinating look at the true mechanics of justice. Definitely something to think about the next time you read about a high-profile court case. Thank you so much for joining me for this explainer, and keep questioning how our systems truly work.